investor documents, how do you get them ready? You may be a company owner, you may have a managerial position in the business, and you may be looking at how do we get ready to prepare documents for investors, right? Whether that's an offering circular, offering memorandum, crowdfunding documents, whatever the case may be, at some point in your company's history, you may be looking to prepare documentation to explain your company, to explain investment opportunity, and to really try to bring other people's capital into your business. And we're going to jump into that today with some short lessons. This is a tough area. It has a lot of complexity to it, but this should at least give you a general overview and idea of some of the challenges, some of the things you need to be thinking about, and how you can really start to pull those documents together. Now, we are talking about generally what some people would call securities laws, right? These are laws that govern the offering of investments. And so it's not security in like locks on your door. It's security in that offering interest in a business and the profits and losses of a business. So we'll be talking about legal issues today. We'll be talking about legal issues in a highly specialized area that a lot of lawyers don't even like to touch. So you're getting some insights, you're getting some education, getting some tips. But this is not legal advice. Consult your counsel, your advisor when you're ready to do this. This is one of the most important areas generally where you can get outside legal advice. So go talk to somebody, work through this stuff. This will give you the knowledge and know-how to talk knowledgeably to get the conversation started. But you're going to have to take this to the next level if you're going to do this right and really hit the right balance and be fully compliant. So this is not a substitute for that. This is to get you pointed the right direction. All right, so you need to start with an understanding of securities laws, right? These are the laws that govern the offering of interests in companies. Now, I did a video separately on securities law 101. One thing you want to know is you're either registered or exempt, right? So you've got to put yourself in that bucket. Almost every private transaction is going to go for an exemption, right? So unless you're a large company, unless for some other reason you've already registered with the SEC, most people want to go that route of getting an exemption because registering with the SEC, potentially registering at the state level, can be a very cumbersome process. So you need to understand that. And then you need to understand that even under the exemption system, there are conditions and rules placed on how you offer that stock and security, right? You have to understand how that process comes together. So you need to understand these laws are there. And the best way you're going to understand them, obviously, is to get some quality outside legal advice that's going to walk you through the exemption process, walk you through the conditions of that exemption, and walk you through making sure that you have the right structure in place before you even do the offering. Then once you get past that stage, then putting together the offering documents in a way that's beneficial to you, protects you, and really communicates well with your investors too, because you want to get that relationship down. One of the things you're going to want to figure out in this securities law review or analysis with your advisor is what disclosures to investors are required, right? What do these people need to know? This is one of the reasons people often avoid unaccredited investors. Often when you bring in unaccredited investors, you step up the bar for the amount of information that you need to give these folks, right? Accredited investors often are determined to be able to fend for themselves. So if you're bringing in accredited investors, that is investors who have either significant income or significant wealth based on definitions in the federal securities laws, generally have net worth over $1 million excluding their home, income $200,000 a year sustained for themselves, $300,000 a year with their spouse. You either have these income, asset, or other tests you pass to become this category of accredited investors. Those folks are generally viewed for whatever reason to be able to fend for themselves. For other folks, you need to have a more comprehensive disclosure. These are your non-accredited people that do not meet the definition of accredited. So You then have to go look at that and figure out what disclosures you have to give them. So again, good counsel is going to get this laid out for you, but you want to start from knowing what do you have to say. Now that's not going to be the limit of what you can say. Sometimes and often it's advisable to give even more information than what you're required by rule to give. But you need to know what's required so you can start with that framework. You and your management team need to collect information. For some companies, this process goes quickly, smoothly, and easily. If you have your files and your accounting's well organized and your corporate documents are in order and your structure is very simple, you can collect that information, right? Because you need to tell the story of where is the company now financially, where are we headed, what other owners do we have, ownership percentages. For some companies, very simple exercise can be pulled together in a matter of a day or two. For other companies, the records aren't as good. You may have longer histories, more complexity. You may spend more time in this information collection phase preparing to disclose the required information and disclose the other things you may be advisable to disclose. In general, when you prepare your documents that are going to these potential investors, in general, you're going to want to give more information than less. Now, the knee-jerk reaction of most people or most companies is to give less information, to limit what goes out, and to really keep things close to the vest. It saves time. It's certainly easier, and it takes away a lot of questions and complexity. But in general, the more you give the investor, the more you're protecting yourself, right? Because you're giving them a better idea of what they're investing in. It becomes less likely they can complain that you didn't get full information. So generally, you want to do more explanation of the company, more explanation of the financials, more details about what's happening. Now, what you don't want to do is put so much more in there that your document becomes repetitive, clumsy, internally inconsistent, or so big that you accidentally put information in there which is just not true, right? So while I know most companies want to tell the truth, they want to get the right information out there, if your document becomes too large, too unwieldy, it becomes possible that there is just inaccurate information which is buried somewhere. Maybe it came from an old draft. Maybe somebody accidentally misunderstood something. Maybe it got missed in revision. So what you want to do is give a lot of information to your investors in general, but you don't want to give so much information that you complicate your life and it doesn't work. You want to think of and anticipate investor questions, and this is really where I spend a lot of time with my clients. And having been down this path many times, keeping in touch with the business and investor world, and having done a lot of these deals, I can start thinking in terms of what would an investor ask, right? What would the holes be? If I was an investor buying in this company, what would I want to know? And I can then start tailoring to that. And I think more businesses need to do that type of analysis. A lot of times in securities law, the standard becomes, did you disclose material information, right? Did you give the stuff that a reasonable investor would want to see? These are types of standards we see in some of the case law in different places. So you want to think and anticipate these investor questions in advance, and you want to get your documents tied into these investor questions. The best is if you get them tied into the investor questions, answering those questions before they even become questions, right? That shows that you're on the ball. It shows an openness, transparency, shows that you're prepared, and it also then thwarts some of these potential claims down the road that you didn't disclose things, right? Because if you disclose the types of questions an investor would ask, of course, hindsight's always 20/20, but it's less likely somebody's going to come back and complain if you do a good job on the front end. After you prepare everything, you want to reread and adjust your documents, right? So, one thing you can do, it depends on what form you're using, but you got to figure out what you got to disclose to the investors. You want to create a checklist of that. And then as your document starts to build and near completion, you want to reread that document and adjust it. And this is usually an iterative process between the management and the lawyer, right? So usually when we do one of these documents, I'll be working with the client. We'll be preparing the document, but there'll be a back and forth between the lawyer and the client as far as, do we want to adjust this section? Do we want to change this section? Is this an accurate statement? Is this what you meant to say? So you want to keep rereading and adjusting your document up until the end. A couple iterations is usually a very good thing on a securities offering document, right? You want to make sure you're protecting yourself. So reread everything and adjust it. And then you want to be careful how you interface with investors. We talked earlier, registered or exempt, right? Which bucket are you in? You want to then be careful with how you interface with those investors because you want to make sure that you do not make wrong statements, incorrect statements, even though the written is usually going to control over the oral in many cases, depending on what's disclosed, right? You're going to try to get them tied into the written document, but you want to be careful on that. And you also don't want to necessarily blow any general solicitation limitations you will have. Often in securities law, depending on how you're getting your exemption, how things are going, you have to keep some of this information private. You can't even necessarily tell the whole world that you're doing a securities offering. So you want to be very careful of how this, interaction process is done so that you don't create problems for yourself. This is not simple stuff, but it is doable stuff. Many companies do this. Many companies do it without ever having an issue with the regulators because they do the homework and they build the documents right and they interface with their investors the right way. Those basic things of complying, of full disclosure, of openness and transparency with your investors, both openness and transparency as you're doing the offering and then openness and transparency after the offering. These all act to mitigate the risk of a problem. So I want you to think in terms of that. You want to do this whole process in terms of thinking about managing your risk. People get upset when they're kept in the dark. People get upset when they're not told things. People get upset when the truth doesn't match the story. So you can have a good opportunity to avoid a lot of that in your documents, which is why these documents become so critical. So I encourage you to get good counsel, to look at your exemptions and look at your process plan before you get too deep into the documents. But once you get into the documents, start thinking about meeting those disclosure requirements and the types of things we talked about today. It'll take you a long way. If you have specific questions, drop them here on the channel. I always enjoy reading your comments. And, if there's particular issues popping up, I will try to cover them in future videos. As a reminder, obviously if you're commenting on a video, there's no confidentiality. So be careful about what you disclose. But I do enjoy reading about what you have going on and issues you may need covered in future videos. So I look forward to reacting with you down in the comment section. Our Shawn McBride signing off. Give me a subscribe and a like if you're enjoying this so we can get you more content like it.